Great pleasure to be back here now and talking to you again about some of the life for employers after lockdown. I think if we look at the next slide, we can see from the agenda that this is a pretty fast moving pace. And I suppose, like all good lawyers, it has to come with a bit of a health warning, which is that this is our best understanding as we stand here now. But if we've learned anything in the last few months, new changes, new schemes come and go, but also the rules within those schemes change. And where there's been some significant changes, for example, in relation to holiday, for example, I'm actually going to pick those up here. But also when we're looking at the new changes, so the proposed revisions, for example, to the job retention scheme, these are subject to change and they will change as things develop. So we're going to look, first of all, at creating a COVID-19 secure workplace. We're then going to look at an update on furlough or the job retention scheme post the 1st of August and beyond. And then we're going to also consider various other things which have cropped up in the last month, which I think are quite useful and which I would really like to share with you. And then at the end, we're going to deal with some questions. And I know that Cress has a selection of questions which you've sent in advance, which is great. But also, I think we can deal with any questions that are sent in during the course of the webinar. So if we look at the next slide, we're going to talk about creating that COVID-19 secure workplace. This all cropped up really on the 11th of May with the now infamous Bojo statement. The response to that, I think, was mixed, but generally, I think there was a perception that once everybody got over the shock and realised they weren't expected back at work the next day, and some people really did actually turn up from furlough the next day, but it became apparent that we were going to be going back to work in a more formal sense, and that there would need to be a lot of preparation and guidance. So to deal with that after the statement, and we could argue all day about whether or not the guidance should have been ready earlier, but it wasn't, we had the publication of a number of specific pieces of guidance for 8 specific sectors and ongoing additional guidance. And you'll be pleased to know that we're not going to cover off schools or places of learning, which have got numerous guidance all of their own, and I think it's a bit beyond the scope of this talk. I think it is relevant, though, to recap what are the 8 sectors that are covered by this initial guidance. So we've got construction and outdoor work, we've got plants, warehouses and factories, we've got laboratories and research facilities, we've got offices and contact centres, we've got other people's houses, so that will be cleaners, housekeepers, nannies, things of that type, restaurants offering takeaways or delivery, shops and branches, and people who work from vehicles. And the key point, I would say, is that for most clients, and indeed ourselves even as a legal business, we found that we were covered by more than one guide. So I think it's very important to read quite widely, because there are tidbits, as it were, of good information in guides which don't really always appear to be particularly relevant to you. But it's apparent to see that a number of businesses would have, for example, warehouses and shops. They might have contact centres. So think broad. The other key point to make is that there are common features to all of the guidance. So the first is work from home if you can. I think there's a specific question on this later on. But the point is the guidance remains the same. If people can work from home, they should. Second point is this carrying out a COVID-19 risk assessment and consultation with workers and/or unions. The risk assessment in final form needs to be published on a website. We've got more than 50 employees. But I think it's really important that you can demonstrate that some type of consultation has taken place, albeit in these socially distanced times. For a number of clients, that has involved effectively emailing out and/or posting on the intranet the draft risk assessment and seeking commentary, particularly where they don't have any elected representatives in place. The other point to make as well is, what do we mean by consultation? Well, consultation means listening and discussion. It doesn't mean agreement. So it's perfectly possible to have an effective consultation without agreeing with the workers and/or the unions every aspect of the risk assessment. I think that's incredibly important, because I think some people's perception of consultation is you agree with me, which isn't quite the same thing. The next point is maintaining the social distancing wherever possible. And at the moment, we know that's the 2-metre rule. That may, of course, change. Certainly for many workplaces, even your standard office, to maintain 2 meters is a massive ask. And I think the estimate is for most workplaces, we're looking at 30% of normal capacity. So that is quite a big shift, and obviously ties in with things like the working from home. The managing transmission risk where social distancing is not possible, and we'll talk a little bit more about this, particularly the need to provide PPE, the need to provide hand sanitizer, gloves, masks, etc. And again, the reinforcement of cleaning processes. I think this in practice means more cleaning, more deep cleaning, and more cleaning generally. So I think all of those apply to any employer. And it's not a question of just doing it, one needs to demonstrate that one is doing it as well. Introduction of health and safety with the COVID return. I think the start point has got to be your existing health and safety policy, which will probably need to be amended. And at this point, I think it's really important to bear in mind that there is no new legislation. So all of this return to work policy falls within the existing health and safety legislation, of which I think there are 2 main pillars. One is having a safe system of work, and one is having a safe place of work. On top of that, we also have what we call the employer's implied duty of trust and confidence. And it seems to me to be that providing a COVID-19 safe workforce and workplace falls within that obligation. Next is the introduction of a sustainable home working policy across the board. Many of us bounced into home working without any real policy, haven't really done very many risk assessments at all, apart from looking after people's mental health, which seems to have had quite rightly a lot of attention. Their physical well-being when working from home has had rather less. But also a policy for those individuals who are shielding and caring for the vulnerable. And I'll come back on to this in a moment, but effectively we're talking about the 2.2 million who were identified as being extremely vulnerable and are in receipt of a letter from government to that effect that told them to shield or self-isolate for 12 weeks. And this other group of vulnerable individuals, particularly those individuals with long-standing conditions, diabetes, asthma, and those individuals who are pregnant. So again, need to have a clear policy because we need to ensure consistency. And we have to somehow manage the hierarchy of need between these different groups. The next element to consider is really what we talk about is appropriate training and protective equipment. In the original draft of the guidance, there was going to be a perception that there would be a requirement for PPE pretty much across the board. That was dropped, I think, because of the well-documented issues in relation to the supply chain. But it certainly seems appropriate to consider what is relevant to your own particular organisation and also particular staff. So, for example, the sanitizer, the gloves, the masks, again, may be relevant to some and not to others. I think, again, the training, very important. We need to ensure that individuals are trained on how to socially distance and what is acceptable. And as in all cases, we need to be able to document that they have attended that training and keep a record of it. If we attend training and we don't document that, there was absolutely no point probably having it in the first place. So very important that those records are maintained. Fourth point on the slide is this question about reviewing whistleblowing and related policies. I think, again, this is how do we deal with complaints and raise awareness, for example, such as whistleblowing helplines, the HSE, etc. Because there's no doubt that we will see, doubtless, some complaints and an increase and a spike. And I think the HSE have been given several £1 million to deal with this spike in complaints. And obviously, as employers, wherever possible, it is much better if we can deal with those complaints in an internal process. So, for example, if you have a health and safety committee, make sure that that is meeting, albeit remotely, or socially distanced as required, or maybe a mixture of both. And it's probably appropriate, for example, to have a specific section added to the standing agenda in relation to COVID-19 related queries and concerns. And then the last point on the slide is this updating the contingency plan for future lockdowns. Most contingency plans were clearly premised on the basis that if a client, for example, had 3 centres, one centre might go down, but the other 2 would continue. We know, of course, that isn't quite what happened here. We also know, and I think it's been given very broad hints from government, that there will be localised lockdowns envisaged if required. So I think it's incredibly important that we take the opportunity to update the contingency plans and work out the lessons learned from the recent experience and how they can be improved going forward, particularly for, say, a national organisation with different depots where some may be in lockdown and others may not. So again, I think very important just to make sure that that is updated now we have a little bit more time. I've already talked about this really, but it has caused quite a lot of controversy with a number of clients. We look at the distinction between the vulnerable and the extra vulnerable. We know that over the weekend, the extra vulnerable, so the people, the 2.2 million in receipt of the letter from government, were told that they could relax their isolation a little bit, but it is still clear that they should not be expected to work from any location outside of their home. The vulnerable, on the other hand, I think the question there is a duty to treat them differently, but that they can be expected normally to go back from site if they cannot work from home. But they have got additional protection. And certainly some of the vulnerable may in fact have a disability within the meaning of the legislation, whilst the extra vulnerable, strange though it may seem, may not. So I think it's really important that when you're assessing concerns from employees, and particularly those employees who do not think that they can return to work because they are either one of these groups or shielding someone or living with somebody in one of these groups, that we address those concerns. Because I think, again, there is going to be a number of issues about how people do come back to work and how we encourage them and support them to do so, as well as what do we do if they refuse. And I'm going to cover that in one of the questions later on. I think the other key point to make, which again is a bit of a nonsense, but again is a bit unclear, is what are critical roles on site? Why do people need to work on return to site? Is it because there is a need to demonstrate some fairness or presenteeism, which I've heard argued by certain employers, or is it actually a critical role? And again, I think if we're looking at our risk assessments, we need to be really clear about why some roles need to be performed on site and others do not. The second point on the slide, obviously, are the employees with childcare issues, and this has cropped up a lot. The benefit of the furlough scheme for many businesses is that it has effectively avoided some of these really tricky issues. The return to school is assisting a few, but probably causing more confusion for many, given that a number of employees will have some children who can go back to school and other children who cannot, and who looks after the children who may still be very little, who cannot. So again, we're told by the Prime Minister that these members of staff are to be protected, but it's not clear under what legislation they're to be protected, by who, and at whose cost. So again, I think we have to look at some of the other alternatives which you may wish to consider. The first is your standard flexible working request, albeit on a temporary basis to enable individuals to reduce their hours to deal with childcare, or indeed to take unpaid leave. We talk a lot about the requirement of unpaid parental leave for up to 4 weeks per child, so possibly something that could be looked at. And again, we have what we call emergency time off for dependents. The key there, of course, is emergency, to arrange the childcare, not to provide childcare for several weeks. So there is undoubtedly a number of issues that arise from this. And again, if we go back to our policy, we need to ensure consistency. It all stands and falls really on this consistency point. And then the next point on the slide, again, which is becoming quite an issue, is in relation to sort of medical testing. We've all seen the temperature checks as individuals go into buildings, and who records both the temperature checks and other types of testing. Clearly, the Information Commissioner is concerned that this data may be perceived as sensitive, and therefore is subject to the usual horrible GDPR principles in terms of proportionality. Is it justifiable to keep the information? How long are we going to keep it? And who sees it? Does the manager need to know that an individual has tested positive or indeed has a high temperature? Is it sufficient for the occupational health team to know, and or the HR team, depending on the organisation? So very important to read the guidance, which gives some pretty clear views. The key point is as little as necessary, which I think we would all agree with, because I think handling and retaining this information generally creates more problems than it solves. There are, however, a number of gaps in relation to this, and in particular, there's no mention so far in the guidance of what do we do about any requirement about staff testing? What about individuals who have been tested, and can we expect them to provide details of their NHS related test? What do we do about questionnaires? Do we think questionnaires have any value at all? What happens if people are less than straightforward? Other key areas which I think have yet to be resolved is this whole issue about public transport. It would be lovely to think we could cycle everywhere, but to be frank, cycling from North Leeds right to South Yorkshire is not an attractive prospect. And we know that the public transport system is not designed to cope with anything like the number of staff who might normally use it. So how do we deal with those people? What alternative measures do we take into place? And then finally, we know that a number of individuals, because of their underlying health concerns, and indeed those of their household, but particularly their own individual concerns, may find it very difficult to return to work. Equally, if we need a certain number of individuals to return to work and/or we're looking at redundancies, it is pretty difficult to see how we can balance those two obligations, because obviously if we're looking at making redundancies, we do need to retain staff who are actually able to work and perform the role. And I think that's why there's some interest in what further guidance will be forthcoming from government, hopefully at the end of June, which will be setting out some guidance as to what is or is not a reasonable approach. But I think it's already been flagged up by the Equalities Commission that there clearly is a risk of a disability discrimination claim if an individual who is self-shielding because they're extra vulnerable is automatically perceived as first in line for redundancies. So I think that's a watch this space, but certainly as we go through this issue, we need to be aware of it. Now, clearly, we've talked about what we're going to do when people come back to work. I think it's already apparent that a number of individuals may never come back to work. And certainly, I think this concern about the retention of jobs was obviously the original basis for the job retention scheme. And I think, again, the cost of the scheme, however, has necessitated a review, perhaps unexpectedly or perhaps to be expected. And we got further guidance on the 29th of May 2020. Well, I say we got further guidance. We were told the outline, but we know that further guidance will be prepared. So what are the key dates? Well, the first is there is an end date of the 31st of October 2020. There are no extensions and there are no exceptions. That may change, but at the moment it ends. The second point is this business about the deadline for furloughing staff. So effectively, to make a claim, you have to be on furlough as at the 1st of July, and also you have to be furloughed for a minimum period of 3 weeks. And there is a specific question raised about the extent to which individuals who have been on furlough can be brought back from furlough, can then be re-furloughed again, and are they still covered by the scheme? And I'm going to deal with that specifically. And then the last point, which again I think is generally welcomed, but probably not across all sectors, is this concept of the flexible furlough from the 1st of July. Previously, we had as lawyers a number of queries about what is the definition of working, and in particular this distinction between personal development and the so-called training exception. And it would be fair to say that there are a number of organisations that I think have stretched this flexible training development, what is working definition to its nth degree. And it's probably no accident that yesterday HMRC announced that they will be prosecuting directors of businesses where they felt this definition had been stretched and individuals had in fact worked in prohibition of the furlough designation. But going forward, we won't have to do that angels on pin type of definition. And we know that individuals will be able to go back on a part-time basis. And probably the easiest way of explaining this is to give you an example. So if I go back to work for 2 days and I'm furloughed for 3, then the employer will pay 100% of the salary for the 2 days, and the government will pay 80% of the wages for the 3 furlough days for July and August. It then changes from September onwards. So it's a split. So there will still be a claim for reimbursement, but effectively, as an employer, you will pay for what you get, but the employee's salary will also be protected to a substantial degree. So looking at that in more detail, if we look at the next slide, we know that effectively there will be a tapering of relief, and that tapering will really start from the 1st of August, where the employer will take over responsibility for the national insurance and the pension contributions, up to the cap of the £2,500. 1st of September, the grant from government will reduce to 70%, up to a cap of £2,190. And as of the 1st of October, the grant will reduce to 60%, up to a cost of £1,875. Now, the other observation I would make in relation to that is that a number of organisations and businesses and employers have in fact already topped up the scheme. So I think this is the minimum, but we must remember that an awful lot of individuals and businesses have in fact benefited from a different approach. And this raises a number of specific practical points. So if we look at the next slide, I'll just highlight what I think some of those are. Self-evidently, and at the risk of repetition, it is crucial that if you wish to furlough people, that they are furloughed by the 10th of June. That is imperative. But aside from that, I think another key point is the review of the furlough letter. Bit like our home working policies, because all of this happened at such breakneck speed, a number of those letters are somewhat defective. And now would be an opportunity to try and either reissue the letters and or review them. I'll show you the 3 or the top 4 things in which they are defective in our experience. The first is a number of them included review dates, some didn't, but some did. And an awful lot of clients sort of forgot about the review dates and didn't think they need to bother. They were never particularly clear in the first place how long they thought the furlough was going to last. That obviously has caused issues for clients where individuals have been required to come back to work. There are no specific notice requirements, but clearly, if we look at the general duty of trust and confidence, then we have to give people reasonable notice of the need to return to work. I think the other points as well are clearly under the original agreements, they were told that they could not carry out work, subject to all the usual stuff about whether it is work or is it training or whatever. But we now know with the introduction of flexi furlough, then that needs to be included in a new letter. And again, individuals need to be designated under the new furlough arrangements. And I think the strong argument is that that should be in writing, again, for record keeping and future purposes, but also theoretically, at least, there needs to be an agreement to change. And I do see the argument that's been run, which is there isn't really much consent when it's either you lose your job or you're furloughed. And I do accept that. But the theory is that there needs to be some formal agreement to the change. Again, a number of the original furlough letters were more really in a request of an instruction than any type of discussion. And again, that's something that needs to be looked at. Review of accrued holiday entitlement. I think there are several things to say about this. However, it's clear since the guidance on the 13th of May that an individual can be forced to take holiday whilst on furlough. Again, I think there may be technical differences between types of holiday. So is it my minimum working time holiday, or is it in fact an enhanced holiday? But certainly if we look at the working time holiday, so the 28 days minimum, it seems quite clear through the amendments to the legislation that an individual can be compelled to take that holiday whilst furloughed. Obviously, if they do that, then they need to be paid in full, but 80% of the cost is paid for by the government currently. You will see, therefore, there's quite a lot of attraction for doing this. I think as a start point, it's incredibly important that accrued holiday is very carefully monitored and individuals be requested to take holiday before it is enforced. Key point to say about that is if you're going to force employees to take holiday, they need to have minimum notice. So if it's 1 week, they need 2 weeks prior notice. There's also in the guidance some rather mealy-mouthed words about the employer needs to consider whether or not an individual actually can take meaningful holiday for rest and recuperation whilst being furloughed, which is clearly an arguable point, but I suspect at this stage is something which probably can be quite safely parked pending further review. And certainly I think is preferable to individuals coming back from furlough with substantial holiday entitlement. Key point again as well is that if we look at different types of holiday, we know as well that individuals who were not able to take holiday up to the end of the holiday year at the last tax year, so 31st of March, have been given up to 2 years to take that holiday. Only if, however, it's COVID related. Difficult to tell how you would show that something was not COVID related, in my view. But another reason why, in terms of this year's holiday, so April 2020 onwards, it would be a good idea to avoid a large build-up. Is, of course, the practical problem is, where are we going to go on holiday at the moment? But that is a different issue altogether. Next point on the slide is considering the affordability of top-ups. As I've said, a number of clients have topped up. They've topped up to actual rather than the cap. And for other clients, they have actually gone for a sliding scale. So they've topped up for 100% for month 1, 95% month 2, 90% month 3. Again, I think if this is going to go on to October, there has to be a question of affordability. And again, if we're going to reissue the furlough letters, now would seem a prudent moment to try and put that in place. And then the last point I've made on the slide is the impact of furlough on redundancy, because we know that although the furlough scheme is a retention scheme, it's quite apparent that a number of individuals have been put at risk of redundancy whilst being furloughed. And it seems that the guidance permits that. And indeed, for a number of employers, there are considerable financial benefits in doing that. We know that, for example, acting as a worker representative for the purposes of collective consultation is not work. We know that collective consultation can take place remotely, albeit in a socially distanced fashion or on Zoom. We also know that if an individual receives notice of termination, that notice can be served, it appears, on furlough with a substantial contribution from the job retention scheme. So you can see why it's suddenly become very attractive, particularly for those employers with substantial numbers of potentially redundant staff. Things you can't get, however, are if you decide you're going to pay in lieu of notice, then you meet that cost in full. Similarly, you cannot claim for statutory redundancy pay. So again, I think it is a moot point as to whether or not this is the appropriate use of the scheme. However, it seems to be it's a legal use of the scheme and something which needs to be considered on financial grounds alone. Extension of the statutory sick pay scheme and the statutory sick pay retention scheme, or reimbursement, we should say. So we know that with the test and trace scheme, staff could be told to self-isolate, in which case they would now receive statutory sick pay, even though they may be asymptomatic. And I think crucially, if they're told to self-isolate on a number of different occasions, then they will get that statutory sick pay, so £95.85 per week, each time they have to self-isolate. And there is a specific question about the effect of contractual sick pay in this context as one of the questions, and I'll come back to that later. But the key point as a baseline is this statutory sick pay entitlement. I think it was quite clear that the cost of statutory sick pay for particularly smaller employers was quite significant, and therefore there was a rebate scheme introduced in the end of May, and it applies to those employers with less than 250 employees. You have to have had 250 employees as at the 28th of February. You also have to still have a payroll in place, but connected companies and charities can all make claims. So definitely something, if you fall within that group, to check with your accountants. I think it's very important that this is not reimbursing statutory sick pay across the board. It is only reimbursing statutory sick pay paid to employees who were shielding, self-isolating, or had coronavirus symptoms. Number of points to note about that. To make a claim, you have to notify the days of the sickness and specify which of those days were qualifying days within the meaning of the statutory sick pay scheme. You also have to identify the reasons for absence, for the reasons that it has to be COVID related. So whether you're symptomatic or otherwise, and you have to provide the employee's national insurance number. Key point is that you need to keep the records of the proof, as it were, for 3 years after the date of payment, so not the claim. Those records obviously need to be kept securely because we're already told that they will be audited as part of ordinary payroll, but also extraordinary payroll audits that may in fact be required. And there are two potential claim periods. The first is the 13th of March, where the reduced sum of £94.25 was payable as statutory sick pay for individuals who had COVID-19, symptomatic, were self-isolating or living with somebody with COVID-19. And then the second of the 16th of April claim period is where an individual was shielding because of COVID-19. So there are two distinctions. Very much, I think, something that may not be enormous in terms of financial benefit, but something which is definitely worth, I think, looking out for. Other things to consider, which I think have really become much more apparent to me in the last sort of month. The first is that there is now a specific exception for the provision of a business equipment for exclusive business use to employees to enable them to home work as a result of COVID-19. And it will apply during the tax year 2020 to 2021. So very much something which I think is worth looking at. Second point is insurance claims. Again, it has become apparent to me from talking to several clients that as part of their claims for disruption, etc., they have been able to obtain reimbursement for the costs such as additional laptops and other office equipment. So it's in addition to the tax treatment, but could be something worth looking into if you do have that type of policy. Another addition to that is that it now seems to be accepted by HMRC that an individual could receive up to £6 per week tax-free in terms of these additional household expenses. I'm not aware, however, of many clients who have begun to pay that, but there is no doubt that there have been a number of requests made by employees for those additional expenses, particularly during the early part where the weather was obviously a lot less good and they were using an awful lot more electricity and gas, etc., heating their homes. So there is this exception for the £6 per week, and again is something to flag up perhaps with your own payroll and accountancy teams. Notice pay and furlough, I think we've already really touched on. Suffice to say, there is a legal argument, again, in relation to contractual notice as opposed to statutory. And some commentators consider that you can only claim for the statutory notice, so the 1 week per year of service, and that if it's contractual, then you should be footing the bill for that in total. Again, unproven, something to watch this space. And again, if we've looked at the accrued holiday, there are some commentators and a number of clients have in fact done this, which was instead of allowing individuals to carry over the pre-April holiday, they have actually effectively paid them in lieu of that holiday, and query whether or not that works. Again, I think there's this distinction between working time holiday and non-working time holiday. Working time holiday, of course, is a health and safety related matter. And the only instance in which you can legally pay in lieu is if the employment terminates. So query whether, if you have paid up to clear the decks, as it were, whether or not those were actually lawful payments. And again, I'm sure we will see clarification and probably litigation in relation to those as we come out of this crisis. So those were my initial comments, which I hope you found helpful. And I think the next section, Chris, is the questions.
Thank you, Catherine. Lots of points there to consider. So now on to the questions that I collated prior to the webinar. So firstly, one of our clients has furloughed a group of employees who are at risk of redundancy, as currently there are no vacancies due to a recruitment freeze and therefore no suitable alternative employment to consider. Whilst furloughed, can we still hold the recruitment and selection exercises as and when vacancies do become available? Surely it makes more sense to invite them to an interview or assessment centre whilst they are furloughed in order for them to secure SAEs and therefore avoid redundancy, rather than wait for the end of the furlough period. To attend an interview is not to work, and so common sense says we can do this.
Yeah, well, of course, we're looking at government guidance, not necessarily common sense. I think the problem with that is there is no specific, and I've done quite a lot of research into this question, there is nothing specific that says that you can't do that, or that, in fact, being participating in a selection exercise is in itself working. And I think by analogy with the example I've just given, which is about consulting whilst you are being furloughed, I think you could put this very much in the same category. I think I think it is a real moot point. I think the issue now, I suspect, will be, because we know we can go for flexi furlough as at the 1st of July, probably the temptation will probably be to hold off until then. I certainly know of other clients who, where they have undertaken a process whereby individuals have needed to undertake a detailed assessment day, either remotely and or socially distanced in person, then how they've dealt with it is they've actually taken them off furlough and paid them normally for that day. But I don't think that was because there was a specific clear legal point. I think it was just they felt that was the appropriate thing to do. I think if somebody was simply being spoken to on the telephone about various job options, I suspect that most people would perceive that as not working and that they could have stayed on furlough. But again, I think it's a watch this space. And I do think it's an instance where the flexi furlough should hopefully help.
Great, thank you. Next one, under the new NHS COVID test and trace service, proof of staff members needing to isolate will be available to employers. We would like to ask whether SSP is payable for successive isolations and whether, if an employer chooses to top up self-isolation with company sick pay, there is a discretion not to do so on successive isolations.
I think we've covered part of this in the actual
yeah.
session, which is that the SSP is payable for successive isolations. And again, I think if we've got a discretionary top-up, then I think you could argue that we would exercise the discretion on the first occasion and not on successive isolations. And so long as that's applied consistently, I think that should be okay. But I think what you'd want to do is that if you do top up on the first occasion, you make it clear that when you're exercising your discretion, and for financial grounds or whatever other grounds, but probably financial, I think would be the main rationale, you will not be able to top up successive self-isolations with the company sick pay. And I think it's probably easier to have a real blanket rule, whether it's the first time or the second time, or, you know, the first time only, just because I think if you introduce that element of discretion, I think that could be quite difficult to ensure fairness. So as I say, I think if you're going to top up, I think that's probably fine on the first occasion, and hopefully that will include most people, because I think listening to the scientists, the number of individuals who will have to be successively self-isolating are going to be very unlucky and very unusual.
Okay, thanks. This question has come up, but there might be some additional points as well. Can staff who have already been furloughed and have returned can be furloughed after the 10th of June?
This is a really tricky question. It sounds really straightforward. Because, and in fact, the answer I decided we were going to give yesterday is actually different to the answer which I'm going to give you this morning, because in fact the guidance has changed. The new rules make it clear that the last date you can put the individual on furlough is for the first time is the 10th of June. But the guidance doesn't seem specifically to address the question as to whether employees who were not on furlough as of the 10th of June, but who have been furloughed previously, can be re-furloughed after that date. And I think until probably this morning, the view was that it appeared to be allowed, particularly relevant because a number of businesses have rotated staff on. And surely if you're designated as furloughed, that is once you've been designated once, you retain that opportunity and that protection. I think as of this morning, however, I think the latest thinking is that you probably can't do that. You have to be furloughed as of the 10th of June. And just because you've been furloughed historically, but you're not furloughed as of the 10th of June, would mean that you would not be covered, which could obviously have a number of consequences in relation to the flexi furlough, which only applies to people who have been furloughed at the 10th of June. So many employers, I think, are considering whether or not they should furlough some new people as at the 10th of June to make sure that they can then bring them back on a supported basis come the 1st of July. But at the moment, I think the best guess, and it will doubtless be put out in the guidance, which unhelpfully is not due to be published till the 12th of June, so probably a bit late, is that you can't rely on that past furloughing. You'd have to re-furlough them again.
Great, okay, thanks. Next one, for as long as the government continues to state that people should work from home if they can, and given that our whole agency has been able to work from home since mid-March, are we obliged to continue working this way? Or can we actually begin phasing back into the office?
I think this is really a very difficult question, because I think if individuals have demonstrated that they can work perfectly happily from home and can be perfectly productive, I think one can expect a raft of flexible working requests to be permanently home-based. I think what the government's guidance at the moment is clear is that if you can work at home, you should. So in answer to that question, I wouldn't quite call it an obligation, but the expectation is that any phasing back to the office would be very limited, in line with that guidance. As the lockdown, I think, comes off, I suspect there will be a stronger driver to return. But I suppose the question I would have is, why do we feel we need to phase back into the office? Is there a business need, or is there some other underlying concern?
Okay. Next question. During the Easter holidays, colleagues were using 1 day of holiday per week of furlough. They were then paid 100% of pay. However, a bank holiday fell in 2 of those weeks. Should they have then had the bank holidays back?
It depends. Did you pay them normally for the bank holiday on the 100%? I think that's the issue. I think the bank holidays, if they were paid the 100% and they had them, I think that would be fine. For some clients, they decided that they would allow them to carry over the bank holidays at a later date. And so effectively, the individual was paid the 80% as normal for the bank holidays, with the view that they can take the bank holiday later on in the year. But obviously, both Easter and May have raised a number of these sort of concerns. And the issue is holiday has to be paid at full pay, so it has to be topped up. And the bank holiday can either be topped up or carried forward. The issue of carrying it forward, of course, though, is that you are going to have these significant accruals.
Okay. So finally, from these questions, what measures should we be looking at from an HR perspective to prepare for any employee-related personal injury claims for physical or mental injuries post the COVID-19 pandemic?
I think the start point goes back to my comments about having a safe system of work and a safe place of work. So it is about the quality of your risk assessment. So if we've not carried out risk assessments of staff working at home, we don't know that they're working in unsuitable conditions, laptops on the back of beds, etc. We've obviously got the risk of significant repetitive stress injury. So again, we need to look at our risk assessments. We need to look at what information we've communicated to staff about looking after their mental health, but also their physical well-being. Have we offered any online exercise classes? Have we encouraged staff to take regular breaks? That sort of thing, because that is all showing that you've exercised your reasonable duty of care, which is the best thing you can do to protect yourself. The other key thing, of course, is we need to make sure that our record keeping is absolutely tip-top, and that where we get any indication from staff that there are issues. So, for example, if we do a staff survey and we found 20% of individuals seem to be suffering from upper limb disorders, we need to be taking some action to do that now.
Okay. There's quite a few questions come through, 8 questions through this. Some I think might have been answered, but I'm going to read them through. So first one, under the new furloughing rules, can employees still be furloughed and unfurloughed on a rotational basis, so long as they were initially furloughed for the 3 weeks minimum before the 30th of June?
They have to be furloughed, as I think we've agreed now that they have to be furloughed as at the 10th of June.
Yeah.
And they have to comply with this 3-week provision. So I think so long as you comply with that, that should work. But of course, the purpose of the flexi furlough is to avoid the need for some of the rotation, because it gives you a lot more flexibility than the either or option that we've had hitherto. So I think there's no reason to suggest, subject to any guidance that comes out, that you can't do it, but you do need to be careful to comply with the 10th of June deadline and the 3-week minimum period deadline. I think there's also some specific changes in terms of how you bring the claims. So claims for people furloughed on the 10th of June have got to be made as at the end of July. So it's really important that those individual employers who haven't yet made their claims get on with it, because I think things may change again.
Okay, thanks. Could someone who is unfurloughed, say on the 10th of June, and therefore working for the last 3 weeks of June, be eligible for furlough again on the 1st of July? And is there no intention to furlough them again for the 3 consecutive weeks in July?
I think they'd have to be furloughed from the 10th of June to the start of July, and then they can be unfurloughed from the start of July. But I think being on furlough at the 10th of July is pretty key in terms of the ability to claim ongoing, and in particular to do this flexi furlough.
Okay. And then the second one from this attendee, for those who are furloughed but working part-time for the 2 months of July and August, but throughout both months, these individuals do not in aggregate or at any individual month level report 3 weeks of non-working time, would they still qualify for re-furlough in, say, October? or are they likely to need to remain non-working for 3 weeks in September?
I think if you've not got them on furlough as of the 10th of June, you will not be able to furlough them again. So if they come off furlough in July, that's it.
Okay. So next one, what if someone is living with someone in the shielding category and is concerned about returning to work?
I think there again, it depends. I think there are some significant issues. I think the start point is to see one, to understand why they can't work from home. If they can't work from home, I think they would need an extra careful risk assessment in relation to, how can we move them into a more secure place? How can we ensure that they are protected? So probably self-isolated in their own office with their own entrance, their own loo, things of that type, really. There will be some organisations, though, that cannot provide a safe workplace. And there the discussion, I think, is it reasonable? Can I refuse to return to work? And I think it's pretty clear that in pure employment terms, you can only refuse to return to work if you feel you are in clear and imminent danger. And I think if an employer has demonstrated through a reasonable risk assessment that they can provide a safe place of work, then that would be a reasonable instruction. So I think we will see a number of claims and disputes, because I suspect ultimately those employees will probably end up being dismissed and there will be a dispute to deal with. So I think for me, it's all about the front loading. So doing everything you can to facilitate their safe return to work. Because certainly for a number of employees, and employers, there are a large proportion of the workforce who fall within this category. I think the other thing as well is it's always worth checking out whether they are shielding because the individual is extra vulnerable, in which case they will have a copy of this letter, or simply vulnerable, in which case I think there's a stronger argument that they should go back into the workplace. But I think in the common mind, there's quite a lot of confusion between the two groups. So I think it is always worth checking.
Okay. Regarding holiday, a further thought here is that those who have not been furloughed and have reduced pay with the anticipation of working full hours will be in need of a holiday.
Absolutely, and they're still accruing holidays, so they can still take holiday.
Yeah.
I think most employers, we need to be, I think generally speaking, because there is no formal carryover process, forgetting about COVID-19, I think employers generally need to make sure that they analyse and make sure and encourage their staff to take holidays. So I have had a number of clients, and we have recommended this, who are actually speaking to their staff now about what their holiday needs are going to be in the next few months. Because we would prefer that people do it by agreement rather than enforcing it. But clearly you do have that mechanism to enforce it. And a number of clients have done an enforced shutdown purely because of demand and to save, energy and cost. But nothing to stop you from encouraging your staff who haven't been furloughed, albeit on the reduced pay. I can see it being quite difficult if you reduced pay on a temporary basis, as opposed to those employers who basically reviewed it on a permanent basis, subject to a review in the future. Because if they're on reduced pay for the next 2 months, but the expectation is they're going to go back to full pay in month 3, they're probably not going to want to take holiday while they're on that reduced pay.
Okay. Regarding the qualifying days of SSP, are the waiting days still going to be paid as at the start of COVID-19 legislation guidance?
My understanding is that they are, because obviously that was a concession right at the beginning. And I think my understanding is that I've not seen any guidance that says that is going to change. I think it may change at some point, but I would imagine probably even for this full tax year, my expectation is that those qualifying days will be a day one right.
Next question. We are wanting to make redundancies for part of our workforce and was considering doing this while some affected are on furlough. Are we better to wait until after the furlough ends, as some are shielding others or are vulnerable themselves, which may make it more difficult?
I think it really depends. I think on pure cost ground, you would start the process now. And particularly because the consultation can be done remotely, and we have done a number of remote redundancy exercises. I think myself, it is proving more difficult to do those remote exercises where we're looking at larger groups, so 20 or more. Just practically, that is proving a bit more difficult. But where we're looking at less than 20, we have already affected a number of perfectly fair, ordinary type of redundancy processes within a reasonable time period, with social distancing and everything taking place on Zoom effectively. And that seems to have worked perfectly well and gets around all of those issues about the shielding and self-isolating. Is of course relevant because we would need to know when that shielding was coming to an end, because we need to know whether or not they're going to be able to return to work given we've got a reduced workforce. But I think given that the shielding letters went out at the end of March or early April and were for an initial period of 12 weeks, subject to any guidance change in June, I think that should probably be okay.
Lovely, thanks. Next one, I have some people who are working from home successfully, but want to work back in the office. The owner wants to bring everyone back, and the result will be those with childcare shielding, etc., also these are part-time, will be working at home. The owner wants them to work their full hours.
I think that is really difficult. I think the bottom line is, because of these social distancing rules, even if people all want to go back into the office, I don't think we can allow them to go back, because I think that would be a breach of our health and safety obligations. So I think you'd be looking at some sort of rotation. Yeah. In terms of the part-time, I think it's justifying why you can't accommodate them on a part-time basis on part-time money and working from home. So if you can justify that, that's fine. I think the problem for many organisations who have historically not been that keen on home working, given that it seems to have worked quite well in an awful lot of their organisations, it's going to be pretty difficult going forward now to argue that it can't work, which is why I think we've seen all the commentary about this being a seismic shift, if you like, in terms of how we view the workplace. But just because I want to go back to work in the office, that doesn't mean that it's the right thing to do. And also, I don't have a right to work in the office.
Okay. Final question now. Question is, can businesses open for the mental health of their employees?
Again, I think it would be really difficult to say that the mental health issues could only be resolved by somebody returning to work. But I think if you felt that was a major problem, going back to my comments about the risk assessments, again, I think it is about the provision of support remotely. And certainly, I think mental health, particularly in terms of the guidance that's available, the employee assistance schemes, etc., it would be quite hard, I think, to argue that that could only be resolved by returning to the workplace. And I would be quite resistant about that. But I certainly think you need to demonstrate that you take an appropriate action to address those concerns. And again, if we go back to the earlier question, that might be a justification perhaps for rotation. So encouraging people back, say, once a fortnight or something of that type, if you like, socially distanced, purely to try and reach that sort of balance.
Lovely, thank you. Very clear delivery of those points there. So I think that rounds up everything. Another reminder to everyone that the recording will be available directly from me afterwards or on our Goldhawk LinkedIn page. Myself and Catherine were discussing yesterday another possible update session, maybe at the end of July, if you felt this would be of interest. We are able to customise these webinars, so your feedback really important to us, so you can get exactly what's relevant to you and your businesses. You will receive an email after this webinar, full feedback, or you can email me directly on this. So once again, thank you to you all for your interest. Thank you for your patience with the log on at the beginning. Means we have gone over time, but hopefully that's all right with everyone. Thank you to Catherine and Keebles for all those many points for consideration. Bye.
Thank you. Bye-bye.
Bye.